to attend our webinar today on OSHA and specifically the Form 300 log that most employers do need to file this time of year. All right, our presenter today is Michael Adams, and he is a partner with us over at SUNZ Insurance Company. It's one of the workers' comp companies that we partner with here to provide to our clients. And so obviously, SUNZ provides tools for clients to assist you and us in controlling losses and reducing the overall workers' comp. You can see he's got a wealth of knowledge, over 28 years of practicing and managing safety and loss prevention activities. So I really do feel we're going to be able to learn a lot from him. He's going to be able to give us a lot of insight, especially on how to properly record the activities, injuries, illness on the OSHA plan. He's also conducted AOE and COE investigations, looking for the root cause, job safety task analysis, conducting risk assessments. That might be something that your company is interested in. We do a lot of those to come out and see how you are performing, what hazards you have, and how to identify and prevent them and give you some tools to fix it. He's also a member of the American Society of Safety Professionals out in California, the member of the American Society for Industrial Security, and he's working on obtaining the Safety Management Specialist designation through the Board of Certified Safety Professionals. So again, he is well overqualified to present this information to us today. So we thank him for coming out and doing so. All right, Michael, you're up.
Great. Hey, thank you so much, Amy, for that introduction. Unfortunately, it is a dry, kind of a dry topic, so I'll do my best to kind of liven it up a little bit. I want to thank everyone again for joining us for this webinar. Before we get into the record-keeping presentation, I kind of wanted to cover some of the updates and give you an understanding of how OSHA's record-keeping and reporting rule affects your business. If you don't know already, OSHA's record-keeping requirements has been around since 1971, and they're under what it does falls under a regulation, and that's 29 Code of Code of Federal Regulations, CFR Part 1904. So again, that's Code of Federal Regulations Part 1904. That is the regulation that the OSHA record-keeping requirement falls under. And basically what it's there for, it's designed to help employers like yourself to recognize workplace hazards and to correct hazardous conditions by keeping track of work-related injuries and illnesses and their causes. So because this is a regulation and you shall do it, that's kind of OSHA's way of saying you have to do this. It kind of forces you to track injuries. So you're tracking and trending. So if you start to see some problem in a certain area, whether it be in a department or a certain area of your location or establishment, it kind of forces you to look at it and see what you can do in order to abate the situation so it doesn't repeat itself. So that's kind of what it's all about. And like I said before, it is kind of a dry subject. This is one of the first things I did as a young safety specialist. After doing it for a couple years, the first month or so, you kind of get the swing of things, and it's a little bit easier the more time you put into it. So basically, I wanted to get into some of the updated revisions when it comes to the record keeping, kind of get that out of the way. So that they're updated, this regulation was updated in 2002, 2015, and 2016. So we're going to kind of reverse engineer this. So I'm going to kind of go into the revisions, then we'll go back and see how we actually do this so we are in compliance. This is one of the first things the compliance officer with OSHA will want to see. So this is kind of their low-hanging fruit. So if they want to see your OSHA log, you got to make sure it is up to date. So that's one of the things you got to make sure you at least look at this weekly, or if you have an incident, make sure it's properly filled out. So, excuse me, I'm kind of fighting a cold right now, so I may take a break and take a quick drink, but if you can please bear with me, I'd appreciate it. So the 2002 revision was written in plain language. So if you ever read OSHA's regulations, they're kind of vague and ambiguous, and it's kind of dry reading. So 2002, what they wanted to kind of do was write it to where it was a little easier to understand. So it's more of like a question and answer format. So they came out with the OSHA Form 300, the OSHA Form 300A, which is the summary of the work-related injuries. And then, of course, the Form 301, which is the injury and illness incident report. So all three of these forms were introduced in 2002. The list of exempted industries were also updated to reflect recent industry data. The revised rules included provisions for record keeping when it comes to needle sticks and sharp injuries, also the repetitive motion. It updated the standard threshold shift, that's the STS, when it comes to hearing loss. And it also talked about the tuberculosis transmission cases. So all these were kind of updated. It also clarified the definition of restricted work or light duty, making it easier to record those type of cases. It also promoted employee awareness and involvement in the process. It also addressed employee privacy concerns. Also, medical treatment and first aid definitions were also modified in hopes of simplifying the recording decisions. Some of the 2015 changes, they updated the record keeping rule. And actually they had two key changes. The first change updated was the list of industries that are exempt from the requirement to routinely keep OSHA injury and illness records due to relatively low occupational injury and illness rates. And the second change expanded the list of severe work-related injuries and illnesses that covered employers that report to OSHA. And this revision retained the requirement to report all fatalities within an 8-hour and added a requirement to report all inpatient hospitalizations, amputations, and loss of an eye within 24 hours. And I remember when that was first revised, there were so many phone calls, influx of phone calls that went into OSHA. I know a couple of compliance officers that, so the duty desk guys were complaining. There were so many calls coming in. So I think that kind of trended downward now, hopefully. But yeah, I know that's when they rolled that regulation out. They were wondering whether or not they made a good decision on that. 2016 changes. That's the third change. That's where OSHA published the injury and illness reporting rule known as the improved tracking of workplace injuries and illnesses. And became effective, that's January 1st of 2017. And this rule didn't change the core requirements of the existing rule, but it did require identified establishments to submit their OSHA 300, their 300A, or their 301 forms to OSHA on an annual basis. And those forms were required, it's dependent on how many employees you had. And at that time it was 250. So with that in mind, it's kind of a bird's eye view of some of the changes that happened the last few years. So now when we talk about record keeping, OSHA record keeping regulations requires employers to prepare, maintain, and submit records of covered employees' serious occupational injuries and illnesses. So again, it kind of forces you to keep track of this. So it gives you a way to track and trend. So if you do see a problem, you're able to kind of nip it in the bud. That's the overall requirement. This is why we do that. This type of information is important for the employers, workers, and OSHA in evaluating workplace safety, understanding industry hazards, and also implementing worker protections to reduce those hazards. So that's what it's trying to do. Once you look at and figure out what that hazard is, you want to try to come up with a corrective action or abatement to get that fixed so it doesn't happen again. So some of the objectives today, Amy, if you can switch that for me. The basic course that we're going to be talking today, designed to provide an overview, a basic overview at that, of annual workplace injury and illnesses, record keeping, and OSHA record reporting requirements. After we go through this presentation, we're hoping that you're able to recognize the benefits of documenting injury and illnesses, determine which workplace injury and illness incidents need to be recorded, explain the process of recording workplace injury and illness data, identify which OSHA form must be made available to employees and how long injury and illness records need to be kept on file. Also describe OSHA's severe injury reporting requirements. And also we're going to discuss the COVID-19 OSHA recordability. I know there's still a little confusion out there, so I'm hoping we can clear some of that up. So when we talk about general record keeping, and that would be the next slide. Let me see here. Make sure I'm on the right one. Yep. The Osha Act of 1970. If you don't know how OSHA started, back in the day, early 70s, we lost more employee workers nationwide than we did in the Vietnam conflict. So if you can think of that number for a second, that's a pretty large number. So that's when President Nixon, actually a bill was introduced to President Nixon in 1970 called the Osha Act, and that's when President Nixon signed it into law to help protect the employees of employers around the United States. So when we talk about the Osha Act, it's basically, every employer shall provide each worker a safe and healthful place in which to work. And of course, I'm paraphrasing that, but that's what it comes down to. So when we talk about the Osha Act of 1970 and the 29 CFR Part 1904, which again, that regulation is recording and reporting injuries and illnesses, is required with a lot of employers that have 11 or more employees, where you need to prepare and maintain records of the occupational injuries and illnesses. Now, according to OSHA, an injury or illness is an abnormal condition or disorder. Injuries include cuts, fractures, sprains, amputations, repetitive motion, those type of injuries. And illnesses could include both acute and chronic. Illness happens right away. Say if you breathe something in, a chemical, and it automatically, that's acute injury because it happens right away. And then you have your chronic, which it takes a longer time for that disease or illness to make itself known. So illnesses such as skin disease, respiratory disorders, or poisoning. What I'm going to do too is I have a bunch of handouts that you'll be able to find on the website later, as Amy indicated. So some of this, if you've never dealt with the OSHA record keeping or OSHA log before, you're going to have a bunch of resources that you can look at later on, which I think will be helpful for you. So that would be one resource, is the introduction to OSHA record keeping that could kind of help you guide through. Next slide, please. If your company had 10 or fewer employees at all times during the last calendar year, you do not need to keep injury and illness records unless OSHA or the BLS is the Bureau of Labor Statistics, informs you in writing that you must keep records. And that falls under section 1904.41 or section 1904.42. So again, you don't need to be taking notes because I'm going to be referencing some regulations just for you to go back and look at, and that will help clarify what I'm stating here. In addition, OSHA's record keeping regulation provides a list of low hazard industries that are exempt from routinely keeping OSHA injury and illness records. So that's a good thing. Some of you may not have to keep it. The list of particularly exempt industries, those are based on the North American Industry Classification System, or as you may know, NAICS, and also injury and illness data from BLS. So when you turn these, I'm kind of backtrack here, when you turn in these OSHA logs, if you file it every year, all this information is gathered by the BLS, Bureau of Labor, the Bureau of Labor Statistics. And what they do is they crunch the numbers, and that's how OSHA determines whether or not what a high hazard workplace will be, or where they may determine if they are going to be have a programmed schedule to go out and visit some type of industry. So they take these numbers, they crunch them, and OSHA gets these numbers, and that's what determines who's going to get inspected that year. Okay, so again, yeah, there will be another handout online, which is called partially exempt industries. So if you're wondering if you're one of those industries, please take the time and get into that website and pull that document. Why document injuries? So the next slide, documenting injury and illnesses records allow OSHA to focus its efforts more effectively to prevent fatalities and severe related injuries and illnesses. So the updated record keeping rule, like we talked about, which took effect of January 1st in 2015, was intended to help improve access by employers, employees, researchers, and the public to information about the workplace safety and health. After looking at it, hopefully they'd be able to increase their ability to identify it and avoid some of these serious hazards. So the all intents and purposes, it was supposed to educate people so they know what the hazards were in their workplace to help determine and help keep themselves safe. Documenting the workplace injuries and illnesses also provides a basis for a statistical program that produces injury illness data and is used by OSHA to measure the agency's efforts. So like I said, the BLS gets these figures, crunches the numbers, and then it's sent out to OSHA. The records also are helpful to employers and employees in identifying and correcting the factors which cause injuries and illnesses in the workplace. Some of the requirements, employers that are covered under 1904 and are required to keep records of work-related injuries and illnesses for an employee on their payroll. They're supposed to cover it for whether they're a laborer, whether they're an executive, if they're hourly, salary, part-time, seasonal. It also includes temporary employees who are not on their payroll if they supervise them on a day-to-day basis. So if you're a company that hires a staffing company, I don't know if you knew this or not, but you are directing their day-to-day work product. So if they get hurt, you are supposed to put that injury on your OSHA log. So that's something to consider when you hire a temporary staffing firm. So also, if your business is organized as a sole proprietorship or partnership, the owner or partners are not considered employees. So some of the recording criteria, knowing what to record is vital to ensure a reliable and prompt collection of data about your employees. After all, the final rule issued to improve tracking of workplace injuries and illnesses, which took part January 1st of 2017, requires the workplace 300 log to be kept current. So it needs to accurately reflect what occurred within the workplace. And that recording criteria is it must be work related, it must be a new case, and it must be a qualifying condition. First, it must be work related. So let's focus on that. This is OSHA's definition of work related. It's not what you might think is the common sense meaning of the word, but work related to OSHA means an event or exposure in the workplace either caused or contributed to the injury or illness, or there is a significant aggravation of a pre-existing injury or illness. So again, work-related to OSHA means event or exposure in the workplace either caused or contributed to the injury or illness, or if there's a significant aggravation, so you have a repeat of the pre-existing injury, so it reoccurs. So that's where you're going to be logging it down. Also, second, when we talk about new cases, on the next slide, it must be a new case. So an injury or illness considered a new case if the employee has not previously experienced a recorded injury or illness of the same type that affects the same part of the body, or if the employee previously experienced a recorded injury or illness of the same type that affected the same part of the body but had recovered completely. So what does that mean? That means all signs and symptoms had disappeared from the previous injury or illness, and an event or exposure in the work environment caused the signs or symptoms to reappear. So that would be another case. Qualifying condition is the third. The injury or illness must have resulted in fatality or death, days away from work, days of restricted work or transfer to another job. And, we look at that as what, modified duty or light duty. Medical treatment beyond first aid, loss of consciousness or diagnosed case of cancer or chronic irreversible diseases, fractured or cracked bones or teeth, and punctured eardrums. There are also special recording criteria for work-related cases involving needle sticks and sharp injuries, medical removal, hearing loss, and tuberculosis. So those would be your qualifying conditions. Next slide, please. There are exceptions to work-relatedness you should be familiar with. And understanding the exceptions and how OSHA applies them can save you a lot of time and headaches. And I wish I knew a lot of this when I first started out. I was kind of a sink or swim here. This is what you need to do. So a lot of my training was kind of reading it on my own, but I finally got it right. So hopefully this will kind of save you some time and headaches just by going through some of this stuff. So what's recordable and what is not? So there's 9 exceptions that we're going to cover today that will not have you record these. So this is why it's important to know these. And the first exception on the next slide is general public. So not working on or your day off. So the first exception applies when you have an employee is present in the workplace as a member of the general public. So you work in a store, for example, here, a grocery store, we're using an example, and they come in and on their day off and they're working, or if they're on break or after work, it all applies. So you have an example of an employee of a grocery store who gets injured while shopping there on her day off, that would be exempt. So that's an imperative why you keep good time records, by a time clock or however you track someone's time punches. That's important. That'd be the first exception. The second exception on the next slide is when symptoms surface at work but are caused solely on a non-work related event or exposure. And we're using, for example, where if you have an employee that has an epilepsy seizure and falls and breaks his arm, the injury was caused solely by the seizure, which is epilepsy, and epilepsy is not an occupational condition, so the injury is exempt from recording. So again, obviously there's several others, but we're using that as an example. So that would be another exception. The third exception to the rule is when an injury that results solely from voluntary participation. And I know a lot of folks in HR always looks at this, and since I've been working, we're always determining whether or not if this would be a recordable. So any voluntary participation in a wellness program or medical, fitness, recreational activity, say blood donation, physical examination, flu shot. Here, the picture, a company picnic, for example, exercise class, racquetball, softball team. That is an exception, and should not be logged. So volunteer participation. The fourth exception involves illnesses that result solely from eating or preparing food, whether the food is brought in by the employee or is purchased in the workplace, like say a cafeteria, for example, employee cafeteria. However, if an employee gets food poisoning from a meal provided by the employer, says for example, for a business meeting, that would be work related. But an allergic reaction to a meal provided by the company is not work related. Other injuries that occur in a lunchroom or kitchen, like say slip and falls, those aren't covered by the exception, and that may result in a recordable case. The fifth exception covers injuries that result from employees doing personal tasks that are unrelated to their jobs and that involve activities that are outside of assigned work hours. To be exempt, both conditions must be in place. For instance, if a worker arrives early, an hour early, to do some personal work on a company computer, or say if they come in an hour early and work on a craft, a hobby, and they get hurt, they're engaged in a personal task that is outside of assigned working hours, that would also be an exception. So that would not be work related. The sixth exception, injuries are not recordable if they are solely the result of personal grooming, self-medication to treatment, to a non-work condition, or are intentionally self-inflicted, like attempted suicide. I know that's sad to say, but this is the example that Osha uses. However, if an employee falls and is injured while showering to remove, say, a contaminant that he or she was exposed to on the job, it would be a recordable incident. Although drug and alcohol use fall under this exception, to not be recordable, to claim that an injury is not recordable because of drug or alcohol use, it must be solely the result of drug or alcohol use. I know that's a mouthful and kind of hard to follow. So, like, in other words, if a worker is injured operating a forklift and you do a post-accident drug test that comes back positive, it will still be considered work-related because the drug use isn't the sole cause. Rather, the forklift operations played a part. And that again had a lot of spirited debates on this. You know, when someone like comes back and they find THC in their system, and you know, they ran someone over in their forklift. You know, that's which happens more than I like to admit in you know, warehouses and things like that. That's always a spirited debate, to say the least. But that's how OSHA looks at it. The next exception is for injuries that result from a motor vehicle accident in a company parking lot or on an access road, and also during the employee's commute to and or from work. So other injuries in the parking lot or access road are work related and potentially recordable. So if an employee is injured by slipping on ice or tripping in a pothole while walking from a car, you know, to the office or facility or the warehouse or whatever, that would be recordable. However, if an employee is struck by a car in the company parking lot driven by another employee who is engaged in commuting, the injury is not recordable because the employer has no control over the driver of the vehicle. Okay, so that would not be recordable. You have no control over that driver that hit the other employee while walking into work. So next slide, number 8 and 9. Common cold and the seasonal flu are not recordable, even if the illnesses are contracted at work. So, you know, when COVID first came out, you know, in my mind, it was, you know, somewhat like the flu. So here later when we talk about the COVID-19, I'm hoping I can clarify the difference between the two. But so the exceptions, the 8 and the last one, number 9, are the common cold and seasonal flu are not recordable, even if illnesses are contracted at work. So mental illness is not recordable unless the employee voluntarily provides an opinion from a medical professional with appropriate training and experience, such as, and what do we have here? Psychiatrist, psychologist, or a psychiatric nurse practitioner, or a similar specialist stating that the employee has a mental illness that is work-related, then it would be a recordable case. Now, with this in mind, and I think I brought it up in the beginning, but this is federal OSHA. And one thing you got to take in consideration that I was going to bring on later because of COVID is there are site-specific OSHA. So where this is federal OSHA, you might want to refer to your state OSHA approved state plans. And this is something that I'll get into at the end of the presentation. So you have federal OSHA, then you might have your state approved OSHA plan, which I believe now there's 28 of them. So if you're somewhere in California and we're talking about the mental illness is not recordable, that may be different in California. And this is why you need to look at Cal OSHA's regulations, because that may differ, because Cal OSHA is a little bit more stringent than a lot of the other states out there. So that's just something to consider. Next slide, please. So there's 4 recordable illness categories. So OSHA requires each injury or illness be classified into one of 4 categories. One is fatalities. 2, days away from work. 3, job transfer or restriction. And 4 is other recordable cases. So those are the 4 recordable and illness categories. So the next slide, if a fatality or death occurs, what you want to do is enter a check mark in the death column of the OSHA Form 300. And let me see if Annie, can you switch that? Uh-oh. Okay.
Do you see the fatality?
Yeah,
Okay.
I should do. Thanks. And I saw a note on there is, I guess there was some echo. Did that echo go away? Okay. Right, so if a fatality or death occurs, you enter the check mark in the death column on the OSHA Form 300. And if you see the little arrow, that's where you're supposed to check it. Indicate whether the case involved an injury or illness in the appropriate column. Due to the nature of this type of incident, you're required to report this type of incident to OSHA sooner than other types. And we'll discuss this in more detail a little bit later. So let's go to the next slide and talk about the days away from work. Some incidents result in an employer or medical professional recommending the employee stay home from work. For cases that involve the employee being away from work 1 or more days, you must check the box on the OSHA 300 log, like it shows up there. And what you want to do is also record the total number of days the employee was away from work in column K. So there you have days away from work. You have 7 away from work, 7 days. In B, you have other recordable cases, which is J. Days away from work is 9. And then for the example, remained at work, days away from work is H. And then 8 are away from work. So that's an example of how those should be checked on your OSHA log. Now the calendar days on the next slide. You must count the number of calendar days the employees was unable to work as a result of the injury or illness. That's regardless of whether or not the employee was scheduled to work on those days. So you have weekend days, holidays, vacation days, or other days off are included in the total number of days recorded if the employee would not have been able to work on those days because of the work-related injury or illness. So do not count the day of the injury. Start with the following day. So if someone leaves, got hurt at 2 o'clock, you don't count that day, you start the next day. Also, there's a day count cap, a maximum. So say if you have someone that are out 180 days, that is the cap per that incident. So if the day count reaches 180 calendar days, stop counting and record at 180 days. It stops there. And any partial day work is considered a day of restricted duty. So if you compare the do not count the day of the injury, start with the following day. Okay, that day would also count as a restricted duty day because they're restricting their work. They went home. So you want to count it appropriately. Transfer restriction. On the next slide, please. There may be a time when you need to record an injury as a job transfer or a restriction. And those aren't bad because, you know, at a workers' comp standpoint, which are two totally different animals, I think everyone knows that. Yet if say workers' comp denies a claim, doesn't mean it's not a recordable. So there's two different directives that you need to follow. So that's why it's important, you know, when we talk about workers' comp, you have your modified duty program in place, and hopefully you can get them back to help out in the office and give them a task to do that would fit the light duty description. But say if it's a job transfer restriction, which is light duty work or a modified duty, that's just a job transfer is just that. It's when an employee is transferred to another job, either temporarily or permanently, because they are no longer able to perform their current job, you know, while they're, you know, recuperating, getting better. So an employee is considered restricted if he or she is unable to work a full shift or is unable to perform all of the work activities he or she would be expected to at least once during a week. So that's where that would be checked, job transfer or restriction. So the next slide, days away and or transfer restriction. If the injury or illness included both days from work and on job transfer restriction, there must be at least 1 day counted in each of these columns. So you're going to check columns K and L. To classify the case, you would check the column to identify the most serious outcome, in this case, days away from work. If there are conflicting medical opinions regarding medical treatment or the need for days away from work or restricted work activity, but the medical treatment is not actually provided and no days away from work or days of work restriction have occurred, then you as the employer may determine which recommendation is the most authoritative and record that on that basis. So you want to go with the one most authoritative if you have those two and you have the option to pick from both those. The next screen, other recordable cases. The cases that involve medical treatment beyond first aid will be classified as other recordable cases. Being able to distinguish between first aid and medical treatment will be key. For OSHA record keeping purposes, medical treatment is any medical treatment for an injury except diagnostic procedures, observation, counseling, and first aid. So OSHA considers that medical treatment is provided once a medication prescription is written, a prescription medication is provided, or the employee is told to take an over-the-counter medication at prescription strength. So I know that's a little confusing as far as the medication. So to determine the prescription strength, dosages for some of the drugs that is going to determine whether or not it's going to be recordable. And you want to know the availability and prescription or non-prescription formulations. This is where you can talk to someone at your walk-in clinic, the doctor, or usually there's a PA or nurse, and or your local pharmacist to determine whether or not it's prescription strength or not. The next, for the purpose part of 1904, first aid is composed of the following. Anything not on the list is by definition a medical treatment. And this will also be on a handout that will be on the website later on. So using non-prescription medication at non-prescription strength is considered first aid. So that's a good thing. Tetanus shots, believe it or not, is first aid. Okay, so basically someone steps on a nail, send them to what we used to do is when I used to work for a large staffing firm, we used to send our people to like a Walgreens or a CVS to get a tetanus shot because it would be considered first aid. So that's a good thing. Cleaning, flushing, or soaking wounds on the surface of the skin is considered first aid. Using wound coverings, first aid. Hot or cold therapy. Non-rigid means of support, such as elastic bandages, wraps, non-rigid back belts, etc. Again, is considered first aid. Now, when we talk about non-rigid versus rigid, rigid being maybe a cast, okay, or a splint. So that wouldn't be first aid. Temporary immobilization devices while transporting an accident victim. Remember, transporting only. Drilling of a fingernail or toenail or draining fluid from a blister, first aid. Using an eye patch, first aid. Using irrigation or cotton swab to remove foreign bodies from the eye, that is considered first aid. Removing splinters or foreign material from areas other than the eye irrigation, tweezers, cotton swabs, or other simple means, those are first aid. Using finger guards, first aid. Using massages or drinking fluids for relief of heat stress is considered first aid. So that's why it's important to have someone that's CPR first aid certified at your location with a fully stocked first aid kit, because you can make a difference in ensuring if a case is going to be recordable or not if first aid is involved. Or making sure you go down to your clinic and talking with the the doctor or the office manager, administrator, or PA, whoever's on duty, and ask them how they handle first aid cases, and just letting them know you have a light duty program, and it helps a lot to getting to know your occupational industrial clinics. Okay, the next slide, we're going to talk about geographic presumption. Not all work-related injuries and illnesses have a clear connection to a specific work activity, condition, or substance that is peculiar to the employment environment. For example, say an employee may trip for no reason on a clean, dry, level, say warehouse or factory floor, or an employee's knee may suddenly buckle even though he or she was walking on an even surface. In these cases, OSHA's geographic presumption of work-related assumes the injury is work-related because it occurred at work, unless one of these exceptions apply. The geographic presumption also covers cases in which an injury or illness results from activities that occur at work but that are not directly productive, like horseplay. Okay, that's one. In other words, if it happens at work, it most likely is work-related according to OSHA's record keeping. Now, it may be different on the workers' comp side of it. That's why it's important if you're at a facility and something like that happens, as a good accident investigator, if you see nothing on the floor, you want to take a picture of it and make sure you document that with your accident report. Okay, so that's important. Just because there's nothing there doesn't mean, it didn't happen. You take a picture of it to show nothing was there. Who knows? People, walk, get dizzy, or whatever the case is. So let's talk about recovery. An employee has recovered completely from a previous injury or illness for purposes of section, that is 1904.6A2, when he or she is fully healed or cured. And this is what we want to see, a fully healed or cured employee. The employer must use their best judgment based on factors such as the passage of time since the symptoms last occurred and the physical appearance of the affected part of the body. So if the signs and symptoms of your employee of a previous injury disappear for a day, only to appear the next day, that's pretty strong evidence that the injury has not properly healed. So again, that's why it's important to, see how your employee is doing, making sure, we call it good claims management, good, being a good employer, making sure your employees are receiving the proper care so they can get back to work as soon as possible. Also, there will be a handout that's on the website called it's a handout titled Recording Decision Tree that will help you through this process. There's 3 OSHA injury record forms that I talked about briefly before. And okay, we're at 46 minutes. Okay, good. OSHA identifies 3 specific forms that we need to use as employers to record injury and illnesses. So the first one is the OSHA 300 log, which we touched on a little bit. The OSHA 301 incident report, which is also considered, and as you know, the Freud report. We're able to use that instead of the OSHA 300 log, and also the 300A, which is the summary. So those are the 3 logs we need to be using in order to be in compliance with this OSHA regulation. So the next slide, we're going to be talking about the OSHA 300 log. So you got to have one of these at each establishment. So each facility, each store, each branch location, each office has to have these at each location. So the OSHA 300 form is the log of work-related injuries and illnesses. So you use this form to document each recordable employee injury and illness. You must enter each case on the OSHA 300 log within 7 calendar days of receiving information that a recordable injury or illness has occurred. Now, if I were you, if an incident happened, you get that information, accident report or the first report of injury, you would want to record that right away. You don't want to wait the whole 7 days because sometimes you forget. So as soon as the incident happens, it behooves you to take that information and put it on your log. And this is how you start to track and trend too. So, obviously you don't want incidents on this log, but if you're in an industry that is prone to some injuries, then, hopefully you'll develop your tracking and trending skills, because you should be looking at this, frequently to see, where we're at. So if you see something that looks out of whack, you need to take a look at it and figure out what you can do to abate that hazard or fix the problem. So you may revise an entry simply by drawing a line through it or amending it further when information justifying the revision becomes available. So what that means is if someone gets hurt and come to find out it was just a first aid, or it's not a recordable after further investigation, because that's what we do, right? Someone gets hurt and you investigate until you find out what the root cause is. So at the end of the day, you may find out it wasn't a recordable. So the proper way to deal with this is basically drawing a line through it and initialing it, stating that you're taking off the log. You don't want to white it out. You don't want to cross it out where you can't see it. Just draw a simple line through it. So for example, if you originally logged a restricted work case that later required days off, you would correct the OSHA log to reflect the change in status for that incident. Again, just drawing a line through it. The OSHA 301 form is the injury and illness incident report, and that is the next slide. Thank you. It's used to record additional details about each individual injury and illness, and you take this information, and this is what you transfer to the OSHA 300 log, because typically this is the form you're going to use first to collect your information. Again, it's also feasible to use your FROI report, your first report of incident or injury that you fill out for you Alpha staff. So you use that form, take that information, you fill out your 300 log. That also needs to be completed within 7 days. Obviously, it's going to be hopefully completed before that. To revise any entry, follow the same process you would use to revise the OSHA 300 log. OSHA does allow you to use the equivalent form, which is an accident report or workers' compensation first report of injury form. And if we look at the 300A log, which is the next, this is kind of the last form that you're going to be using. And this is used at the end of each day. And this is actually what sparked this quick webinar is, sometimes I go out and I go to different places and I do a safety survey. And part of my service is to find out if you have your OSHA 300A form put up in a conspicuous place, because that is the regulation, that's the law. And a lot of times last year that wasn't posted. So this is why we all got together and figured we'd do a quick class on, one, how to fill it out, and two, how to be following the regulation, the federal law, and making sure this is posted in the right place. So at the end of each year, employers are required to prepare and certify this OSHA 300 form. And when I say certify, typically a company executive signs off on it, stating that they certify these numbers are to be true and accurate. This is also called the summary work-related injuries and illnesses, and this should include every reportable injury and or illness incident that occurred during the calendar year, the previous calendar year. So these are last year's results. So I mentioned we have to post this. So on the next slide, it kind of gives you an idea. We take the physical copy of this OSHA form 300A, which is also considered and called the summary. And we need to post this in a conspicuous location within each establishment for employees. So when I mentioned before, using these forms helped educate employees. This is what it is for. So you want to pick a good place to post this, whether you have a safety wall or if you have your federal and state postings, you might want to post it there. So this is a way for your employees to see how we did the previous year in accidents and illnesses. So this form needs to be posted by February 1st and must remain posted through April 30th. So for example, your OSHA form 300A with all recordable incidents from 2020 must be posted by February 1st, 2021. You can remove any posted copies of this OSHA form on May 1st. So right after your time allotted, April 30th, on May 1st, you can remove it. Quick reminder and a quick tip, if throughout the months that this is supposed to be posted, you want to make it a point to check to make sure, like say if you have this in a lunchroom or cafeteria, sometimes people like posting other stuff up there, just make sure that this form is not defaced, altered, or someone else covers it up by something else. Otherwise, it'll be out of the regulation. Termination or retirement, or someone quits. If an illness or injury occurred during employment but was not discovered until after the injured or employee was terminated, the case can be updated within the updating period contained in the section 1904.33. So the case would be recorded on the log, either the year in which the injury or illness occurred or the last date of employment. Some employee rights. OSHA places high emphasis on employee rights. As an employer, you're required to keep sensitive or embarrassing employee information secure at all times. And that would be the next slide, please. Be conscientious of where you're located when discussing specific employee matters. I know we're all professionals here. This is just a quick reminder. For example, would be appropriate to discuss sensitive details of an employee's injury or illness while you're filling up your water bottle. They're at the water fountain per se, or standing in a busy hallway. So again, be diligent about protecting employee information. Some other employee rights. Employees play an active role in organization injury and illness record keeping too. So OSHA requires you to inform all employees of their right to report work-related injuries and illnesses without retaliation. In fact, it is illegal to discriminate against employees who report work-related injuries and illnesses. You can alleviate this by displaying, your OSHA poster, the job safety and health. It's the law poster. You need to post this in a conspicuous place. That's another thing I look at as I go through different locations, making sure you have the proper federal and state postings up. So it'd be good if you can have that posted. So, you're keeping up communication lines open, helping to reduce any potential fear or concern employees may have in their minds. And if you have your little safety chats or your meetings, make sure your workers take the time to read that, because it's some pretty good information, and that's why it's up there. When we talk about employee involvement, workers are required to let employees know how to report work-related injuries and illnesses. So just make sure you develop a system in which there is a way for your employees to report, injuries, incidents, or unsafe conditions. OSHA does not specify how to go about and do it. You have your own freedom. Just remember, it needs to be reasonable. Also, implement incentive programs that promote worker participation in safety-related activities while at work. Making a safety common discussion topic throughout the workplace helps keep safety a priority, and also it helps with your everyday safety culture. So that's a good thing. Drug and alcohol testing on the next slide. As an employer, you're allowed to conduct alcohol and drug testing. That's your choice. But OSHA wants to remind you shouldn't use it as retaliation against an employee for reporting an injury. If your employer conducts drug testing to comply with the requirements of state or federal law or regulation, or with workers' comp, the employer's motive would not be retaliatory. We talk about reporting and storage and retention. When it comes to retention and storage of injury and illness records, you need to keep at least 5 years. So 5 years of documents you need to keep and maintain. As of January 1st of 2015, OSHA requires all employers to report fatalities and severe injury incidents. This applies even to employers who are exempt from routinely keeping OSHA injury and illness records due to the company size or industry. So please review and evaluate your procedures on at least a yearly basis and make revisions as needed. Remember, accurate and timely recording of injuries and illnesses yields accurate events. So recap on what and when to report. All employers must report specific types of incidents to OSHA within a specific time frame. So all related fatalities. If someone passes away, dies on your work site, that must be called into OSHA within 8 hours of you finding out about that. Um, all work-related and patient hospitalizations, which includes work-related amputations, and all work-related losses of an eye must be reported to OSHA within 24 hours of learning about it. Inpatient hospitalizations does not include trips to the hospital for observation or diagnostic testing only, but employers do have to report an inpatient hospitalization due to a heart attack if the heart attack resulted from a work-related incident. Other inclusions, so information to include when reporting a fatality. So if you're calling OSHA, whether you call the OSHA 800 hotline or your local OSHA office, or you do it online, this is some of the information you're going to need: is establish a name, location of the work-related incident, time of the work-related incident, type of reportable event, whether it's a fatality, hospitalization, amputation, or loss of an eye, number of employees who suffered the event, contact person, and his or her phone number, and brief description, a quick synopsis of the work-related incident. Some reporting exceptions on the next slide. There are some exceptions to this rule if the event occurred on a commercial or public transportation system, like a plane, subway, bus, ferry, streetcar, what else? Light rail or train. You do not need to report it to OSHA. Also, if the incident resulted from a motor vehicle accident on a public street or highway, you do not need to report that to OSHA unless it is a construction work zone. So if you, for those out here, have any flaggers that work on construction work zones, if that individual is hit by a vehicle, that needs to be reported to OSHA. So I don't know if you out there offers flaggers to work street companies. That's the only exception. So next slide. Really want to quickly cover some of the COVID-19, what OSHA's been up to. So OSHA requires employers to provide employees with a safe place to work. As we all know now, employers may be responsible for workplace safety violations related to the coronavirus outbreak under OSHA's general duty clause. So we've been talking about 1904 all day. That's a record-keeping regulation. If there isn't a specific OSHA regulation, then what happens is they refer to the Osha Act, which is in essence the general duty clause. This is kind of the catch-all. So under OSHA general duty clause, which requires that each employer, and I said this before, furnishes to each of its employees a workplace that is free from recognized hazards and that are causing or likely to cause death or serious bodily harm. That is the basically what the general duty clause. In a pandemic, an employer could be cited for general duty clause violations where, for example, say if the virus was present in the workplace and the employer's efforts to control exposure were insufficient, employees were required to perform tasks that expose them to the virus without adequate PPE. Okay, this would fall under the general duty clause. And to avoid violating the general duty clause, employers should employ the strategies that are outlined in the OSHA and CDC guidelines and state and local governments. And eliminating hazards from COVID-19 remains a top priority for OSHA. OSHA will, they're continuing to prioritize COVID-19 cases. OSHA is receiving complaints from affected workers in non-essential businesses here in the past. Yeah, that's not a good thing. That means it's spreading a little bit. OSHA will utilize non-formal phone, fax investigations. So that's a good thing. They won't come out to your site, but they'll send you an email, fax, or telephone call to kind of follow up, see what you're doing. So what you should do, please check OSHA's website page. It should be listed down there. Yeah, OSHA.gov, coronavirus for updates. Also, one other thing, I mentioned this before, if you're in a state that has its own program, like I said, there's 28 of them, you need to check that site as well. For example, state of Virginia has their own state-specific OSHA program, and they were the first state where OSHA has mandated PPE for their employees. So this is why if you're in a state that has their own OSHA program, please check that out. So we've seen some confusion over whether or not COVID-19 case is recordable or not. Basically, it is. Confirmed cases of COVID-19 have now been found in nearly all parts of the country. And there's certain outbreaks among workers in industries other than the healthcare, emergency response, or correctional institutions have been identified. So those are, your first response. Many instances, it remains difficult to determine whether a COVID-19 illness is work-related, especially when an employee has experienced potential exposures both in and out of the workplace. So this is why it's important to really understand, how to track this. You need to understand how to do that to see, where they first became ill, and that's a whole other class. So basically, the OSHA enforcement guidance that was revised on May 19th, 2020, under the record-keeping requirements, COVID-19 is a recordable illness, and employers are responsible for recording cases of COVID-19 if the employee is a confirmed case of COVID-19 as defined by the Centers for Disease Control and Prevention. The case is work-related as defined by 29 CFR 1904, and the case involves one or more of the general recording criteria outlined in 29 CFR 1904.7. So this is where, like I said before, this is where your contact tracing protocol will help record if it's recordable or not. With that being said, how to report, you have three options. You can either by telephone, the nearest OSHA office, like I said before, you have the OSHA hotline, and you can also do electronically through the OSHA website. So wrapping it up in summary, I'm hoping that we now understand and recognize the benefits of documenting injury and illness records, explaining the process of recording workplace injury and illness. I hope we learned how to identify which OSHA form must be made available to employees and how long injury and illness records need to be kept on file, and also describe OSHA severe injury reporting requirements. And again, there'll be a plethora of resources for you on the website here in about a week. Thank you so much. I appreciate it. Again, I apologize for going in and out of my voice. I'm losing my voice now. So thank you for your time.
Thank you. Appreciate it, Michael. So I know there was a couple of questions, but I think since we went over, if everyone's okay, which I know you can't tell me yes or no, but I took a picture. I've got them. I'm going to work with Michael to get them out to you today or tomorrow. So that way everybody can go ahead and go off with their day. But additional support, if you do want these slides, please email us at hrsc@alphastaff.com. This also will be the email address to get your credentials for HRCI and SHRM. So send us an email, let us know who to send it to, and we will get those over to you as soon as we can. It will just have the presentation. And then, like I mentioned earlier, next week, it will be on the website with the additional forms and the recorded presentation, so you can review that as well.